Hello, and welcome back to the Business Immigration Benchmark. I'm your host, Laura Billionaires. Today, we're doing something a little different and exciting. We've got Brad Banis and Stephen Brown on the podcast to discuss all their litigation against Department of Homeland Security and especially DOL. And they're going to share their insights and peeking behind the curtain of what they're finding out in the depositions for these government officials and what's really going on there. So with that, we'll jump right in. Brad, Stephen, welcome to the Business Immigration Benchmark. Can you introduce yourselves?
I'm Stephen Brown, a partner here at Newman Brown PC in Houston.
My name is Brad Banis. I'm in Charleston, South Carolina, and happy to be here with Stephen and y'all at Woolsdorf.
Yeah, thanks for joining us. What we really want to get into is, what your practice is and what you all have been doing through litigation and suing USCIS, Department of State, and all those folks.
Yeah, so, my side of things, I do, some petition work, and then Brad and I started working together on various litigation matters on the 2018 H-1B memo, third-party placement, and then delays on H-4 EADs. And we've got a lot more in-depth, a lot more projects since then, and working on that the last 5 years. And now we're working on Department of Labor and how precious the perm processing is.
And Brad, how did you get into this? How did you and Stephen start partnering up on these cases?
Yeah, so I kind of came into immigration through litigation in that I graduated, clerked for a couple of federal judges, and then ended up at the Department of Justice's Office of Immigration Litigation. When I started there and was a, quote, expert in immigration, I had never once filed a petition. I had never seen a petition. I'd been to immigration court once. It was terrifying. And then they sent me around the country to defend the different DHS components, Department of State, Department of Labor, for various types of cases. And so I left the government because I wanted to come back to Charleston, and ended up in like an insurance defense firm because they wanted me to bill hours in federal court because they could charge a lot for it. And I kind of started a more traditional petition practice while I was there. And, but the only thing I really knew to do was, engage in administrative litigation with the government. So I eventually narrowed my practice to do that. And now, 10 years after I left the government, it's pretty much all I do. So any given time, I've got litigation going against the various federal agencies related to immigration for EB-5 or for U-Visa, adjustment of status, and like Stephen mentioned, a kind of a newer project with the perm process. And the fun part about my job is working with petition firms. You guys are the boots on the ground. You see these problems and how they impact clients. And then I can try to help design a litigation solution, or say litigation isn't a solution, because litigation is not a panacea. It doesn't fix every problem. But it seems, especially in the business side of immigration, litigation has never been a viable alternative because you always have the option to refile. And I think in the last 5 years, starting with the H-1B targets and, getting L2s and E2s, work authorization incident to status through litigation, it's starting to become a more normal part of the process. And I still think the immigration community is about 2 decades behind, because in every other regulated industry, litigation has been there keeping the government honest since the beginning. And so I'm a one-trick pony. I know how to sue the government. Sometimes it works, sometimes it doesn't, but that's kind of where I come from. And the Department of Labor stuff we're going to talk about is new and exciting for lots of different reasons.
Yeah, thank you. And before we dive into the DOL litigation, which I'm excited to chat more about, Stephen, how did you get into this? I know you helped us out with that Edenuki settlement. I don't know if I'm saying it right, but my clients are able to benefit. So one, thank you. But how did you get into this, or tell us more about that?
Yeah, so, we were looking at how can we solve the problems for our clients, and there were a couple people talking about litigation at the time. We started pitched the idea. We had talked about litigating H-1B delays. The Trump administration during cap season liked to remove premium, right? And those cases would pen forever. You'd run out of cap gap. And so we talked about that. But those kind of worked themselves. And when they put in the biometrics for H-4s and L-2s, they also stopped processing them concurrently with the H-1B. And in the original outreach, USCIS said, look, we aren't going to be able to do it in the 15 days because we have to do biometrics. We're going to get to them as soon as possible, and we're going to prioritize those files. And everybody knows they never did. Those filings would go on 6, 7, 8, 9, about 12 months. And so we were doing a lot of little case and then big case, group case. COVID hit, we kind of slowed things down because that was going to kind of be a weird time. And what we figured was, Brad was with us on this, was the uni case, bringing a class action we had gathered so much information through different depositions. The Nebraska, the section chief for H-4s for Nebraska had testified. We had depositions from the section chief in Dallas. And we had enough information to go and attack the H-4 and L-2 delays. And then we brought in out of a second case for the L-2. It was the L-2 work authorization and incident to status, as well as the automatic extension for H-4 EADs in limited circumstances. Their own defense, we can't do that because the H-4 is not approved. Certain instances where individuals have the H-4 status automatic, already extended, and they're doing now. But so we looked at that. So we went about that. And I'm really happy to see government finally, even though it's the same thing we had proposed to them a year before, but they finally, capitulated and gave us that. It allowed things to go back to how they were pre-2019. With adjudicating them with the H-1B, and it almost makes sense, right? There's very few differentiating C's with the H-4 that they'd be done by the same officer together.
Right. It seems like it would take longer for them to do them separately. Was always my thought. Like, why would you pick up the file twice?
Absolutely.
When you're getting these government officials and depositions, like, what's your overall take on the administration of immigration law? Like, do you have any thoughts on, you're talking to a person, so person to person, what they're able to do versus like the system? Have you drawn any conclusions based on your time in these depositions?
I will just say this is it's very interesting to see the disparity between what the government writes in their briefs and they put in their declarations in court, and then getting answers at a deposition. I deposed Don Neufeld. Probably know that name from, there's several Neufeld memos. And this was, now 5 years ago, and it was a U visa case. And, he's a nice guy. He's a nice, normal guy, a career bureaucrat, done really well for himself, made it to the top of this new federal agency. And again, a genuinely nice dude. And he would tell me resources. This is all because we don't have enough money, and we're based on fees, so we can't get more money from Congress and all this kind of thing. And then you start in a deposition, it goes on for a couple hours, and then you start to hear the things that they've done to make it more efficient have nothing to do with resources, right? And there are processes that just make no sense that, you're fighting that bureaucratic inertia to change anything. But I just distinctly remember that was true in the Department of Labor deposition we just did, the one in Texas, the woman that you guys put on the stand in Nebraska, that was the H-4 stuff. But it's really interesting to see the disparity again between how DOJ litigates these cases and then how they actually answer the facts questions when you actually have them under oath, because there is a ton of sunlight between those two things.
No, and I think one of the things always that's kind of been eye-opening getting into this sector is you see these public posts, you see the announcements from the administration or from Janelle, and you see what they're saying, right? It's all great. They've got a really good PR team, and then the way they defend some of these cases goes against, these public statements that they're making. And that's always kind of been eye-opening to me. You'll see it on Twitter all the time that, they'll put something up. They're like, you sure? You sure? That's what you're saying something different, in court behind closed doors.
Yeah, that's so interesting. I mean, I definitely have, the practice plays out this way too, that USCIS will issue a policy statement, but the regs still say something different. And so then you're like, well, what is USCIS actually going to adjudicate? Are they going to adjudicate based on this recent administration memo or what the regs really say? And it makes it incredibly difficult to advise clients. And then you have to advise them on a risk for immigration, which is like, you don't really know how the government's going to handle the case, which is absurd in administrative law. Like this should be, if your case meets the facts, you should get the end result you're expecting. And then to not get that, I guess that's when we bring you guys in too.
Well, whoever said predictability is good for business, they're just crazy, right?
Right. Yeah. It's funny when I describe it both to, like HR and they say, well, what do the regs say? I was like, well, there's a little difference here. And yeah, predictability is important for business, and businesses don't want to take risks. And you don't want to take risks in immigration because it could mean having the client exit the US, which is a dramatic end result. It's not like you just pay a fee like, other areas of law, like there's a fine or something like that doesn't exist here.
It's always interesting.
Yeah. Well, I do want to dive into the DOL litigation. So I don't know what you all can kind of tee it up or what you all can speak about, given that it's an ongoing lawsuit.
Yeah, so I could give a bit of background. So I think last spring, our firm, our practice manager for Perm, Crystal Alanis, was so you're suing USCIS with Brad all the time. He has do something about Perm, right? She heads up our Perm team, and she's like, these are getting ridiculous. It's a year long, and then when you factor in ED, you factor in recruitment, the cooling off period. These are, right now almost a 2-year process, right, to get Perm.
Right.
And so we started digging into it. Brad started digging into it with us. And the original 2004, 2005 Perm regulation, the original proposal, they said, hey, we can get these done in 21 days. And their final rule came out more reasonable, 45 to 60 days. And there are attorneys who remember, getting it in 2 weeks, right? And look at everything into it. They thought this was going to be some done by the computers, right? You'd file your perm through it was iCert. It would be done by the computer, and then maybe an analyst gets involved here or there. But it was going to be very quick turnaround, very little human error. And then what made this case very unique is Department of Labor, the Trump administration, in an attempt to shame companies, right? All the DOL, all the perm information for adjudicated perms is readily available online from Department of Labor. So if you go onto the performance data, you can pull down these tens of thousands of line spreadsheets that go through every perm, almost every box on the 9089. And so you now know when it was filed and when it was decided. And so we reached out to a expert statistician. He's a statistical analyst, and said, before we even brought the case, we hired him and said, this is what the government typically argues in a delay case. Here is a ton of data. What do you think? And his first call with Brad and I was like, is this all you want? Like, this is statistics 101. The first in, first out, the line jumping. The typically argument from USCIS, we figured they'd bring over here. Once he did his analysis, we kind of figured a case around that and built the case around his our case very short and from a USCIS case, because USCIS doesn't publish all that data.
Right.
And I should say that sounds like a nuanced difference, but the H4 case, it took us 18 months of litigation in a delay posture, which meant dozens of cases, hundreds of clients, to get a case to last long enough and get a judge to allow us to get the facts.
Right.
And when you're suing DHS or Department of State, they publish some things, but not the stuff you need. So then you're reliant on FOIA, the Freedom of Information Act, and the Freedom of Information Act takes months and years. And so having all of this at our fingertips and being able to make claims of fact that we can support at the outset puts this case, leaps and bounds ahead of where every other CIS case we filed, and it's huge.
So how are you finding? So you're saying, Stephen was saying you set the strategy for the case after looking at the data, because DOL does allow you to access all this data; it's publicly available. How are you finding clients to bring forward a case? Is it through the data?
So, through our normal marketing methods of kind of using social media to reach out to the impacted communities, employers are going to be hesitant.
Right.
I think it's for irrational reasons. You don't see companies getting nervous to sue about environmental regulations or, SEC things or that kind of stuff, but they're nervous to sue about immigration. And I have my own theories on that. But, the good news is most courts have recognized what we call beneficiary standing in this context, meaning obviously the person the perm impacts the most is the employee,
right?
Even though they're not the ones that submitted. And there's this test called the zone of interests, which is incredibly generous and says if Congress intended to protect you, you can sue, essentially. And it's very easy to show the employee protection portions, right, of the Immigration Nationality Act, especially for like the backlogged community where you have, automatic extensions, the 1-year extension, this, that, and the other. And I will say, we wanted to limit the number of clients in a case like this and keep it incredibly cost effective, because we didn't know if we'll succeed, right? The last thing we want to do is go out and push a giant case that just gets tossed out of. So that's, we started small and we're still pretty small. That makes it, it allows us to be more agile and nimble in the litigation, which is really important because we're never going to out-resource the Department of Justice or the Department of Labor, but we can bob and weave faster.
Sure, that makes sense. And Stephen, are you seeing, corporate clients or companies also shy away from litigation?
I think it depends on the context and how it impacts them. If we're talking about a denial of benefits, I think, they're willing to get in. If they have a denied HAP H1 where they can't refile, and I think they're willing to get on board. I think when we're talking about a delay, I think they're interested, and then, when it comes time to sign up, they're like, maybe not so much. I think there's a lot of like Brad said, there's different reasons. Maybe they don't want their name published, or it might be, but there's not any issues I see from companies litigating. In fact, I think some companies, it helps.
Right. I mean, I know from my corporate clients, everyone's complaining about perm processing time in the sense that it's really decimated their ability to sponsor for permanent residents. And, folks are all moving towards national interest waiver, which is a conversation for another time, but that perm programs are really tough, and that I think companies should be really interested because we're seeing more max outs. We're seeing more of their talent have to flow abroad to whether that's affiliate or depart the U.S. or depart the company because of loss of status. I'm sure you've seen this too,
right?
In your cases. So it's it seems like everybody's really interested in seeing perm processing times become reasonable again, which were they ever reasonable? Separate question. So speaking of the DOL perm processing times and the case you're pursuing, what would a successful outcome of this case look like for you? Like what's the goal with the litigation here?
So the immediate goal is to get our plaintiffs perm decisions, period. And they're the heroes, right? We're just guiding them to the end, hopefully, successfully. So that's when we think about the individuals, that's clearly success. When you think about the community, right, success is not just settling them and getting them perm decisions, but getting a decision from a judge that says, no, this is unreasonable. And the first case we filed, again, by design, was in Atlanta, because all of these are made in the Office of Foreign Labor Certification there in, Atlanta. And if we have a district judge say, hey, it is unreasonable in the Northern District of Georgia to take more than 60 days, 90 days to do a perm, that effectively acts as a class solution. And so that was our first, that was by design, and we have a case pending in Atlanta. When you bring a new case, things happen that you don't expect. In Atlanta, again, we went in with our expert report, with all that data, and so we filed for summary judgment, I think 2 weeks after we filed the case. And the government's strategy was to not answer it.
Okay. Not respond. Still have it.
Wow. Okay.
Yeah. And so we thought that maybe they thought it would moot out, meaning everyone would get what they wanted. And then the holidays came, and unfortunately, holidays stop everything in court. And then the new year turned, and we're like, well, let's get this moving. It's not going to settle out. And that's when we started pursuing other courts, because, Atlanta, it's not that we have a bad judge. It's not that we're worried about that, but we want to get more movement. And we had all of the data we are needing. And what's something that Stephen was doing while this case was going on, which is brilliant, is Freedom of Information Act requests. Because believe it or not, the Department of Labor actually responds relatively quickly.
Amazing.
Them and USPS so far are my only ones that can respond to a FOIA within the normal time. That was a pet neighborhood HOA project that I took on.
And you're going to be kept all sorts of things when you get good at it.
But the Department of Labor has been fairly good about responding to FOIA, so we were able to continue to get data and information. One of the things our expert wanted, we would get the perm data says, along with everything of the ETA 9089, when it was filed and when it was adjudicated, right? And we would get some extreme outliers.
Sure.
And he's like, okay, I imagine some of these were audited, but that information is not available. So we provided the data back to DOL and said, we want to list which cases were audited. And sure enough, the case numbers that were audited, and he's able to run his software to, address that and pull those out. We were able to keep making the data better and more effective for our case.
Amazing. Brings up another question. So I know Perm is now on the FLAG website, but we haven't seen any adjudications coming from DOL through the new portal. Do you have any predictions or thoughts on how DOL is going to move into the FLAG adjudications? Because I know I'm a little bit nervous in that we haven't seen any, and that the DOL has in the past had trends of erroneous decisions, of denials and things like that whenever there's been changes.
Yeah, so fun story. DOL doesn't know either. Just like you, Crystal Elise from our office said, hey, can you FOIA how they're going to handle these? The 9089 is largely the same, but there are things that are different. There are minor nuances to the new FLAG one, business necessity statement. There's other things that are new. And I think last fall, we filed a FOIA saying, hey, what training have you done for officers, all your training materials, and then audit, triggers. And they responded back, yeah, we haven't done anything yet. That was, I think, September, October. I filed another one a month later thinking surely they've done something. He said, nope, hadn't done anything. Refer to current regulations that haven't changed. Again, holidays come. We kind of backburner that. I filed another one. We filed another one early January that said, still haven't done anything in March. And then we just got back one last week because we were doing this most recent lawsuit, and I kind of wanted the most up-to-date where they couldn't say, oh no, we did something between March and April, and they still responded in April saying we have not developed anything for the flag system. So Department of Labor has not even touched, trained officers, anything for something that was mandatory in June of last year.
Right.
And that to me is insane, considering that this was a program they took on. It wasn't like Congress said, you have to implement a new system. DOL just said, we're going to do it. And then went into it, ready, fire, aim. And they, yes, they're still working on aim.
Well, I'll be bracing. I mean, obviously those adjudications are delayed, but I feel like in preparing my clients, like I think we're going to see some wild stuff. I mean, if they don't even have any training officers, what are they going to do? Like, I think they're going to take it into their own hands and some in fact.
I will say that three things on this which crack me up is one, I believe, and I could be wrong on this, but when we deposed the administrator of OFLC, he indicated that the OFLC had saved a lot of money, shocking, by emailing out certified perms rather than mailing them. And so I asked, well, what did you do with that savings? And he very quickly told me, we don't call it savings. We call it cost avoidance. And that cost avoidance part of the budget got put back into technology. So I would not be surprised if that helped fund the flag transition. The second thing is this. There's only, we talk about how long it has to train and to figure it out. There's only 12 people that do this in the entire country. 12 full-time adjudicators. So we just got to get them all in one Zoom room. I'll train them. Give me 30 minutes. I'll be like, click the button that says approve, and we're done. So it's not as big of a bureaucratic move as we would like to think.
Okay,
I should say they have 6 other people that do it part-time. They spend half the year doing the time-sensitive H-2As, H-2Bs, and then the other half doing routine perms, not hard perms, routine perm. And then the last thing I will say is, and I'm going to set myself up for failure here, but do not be surprised if in the next 3 weeks, DOL announces something, because we made a lot of hay out of this in our motion for summary judgment in our case in Boston, basically saying you are unlawfully withholding, not unreasonably delaying, but outright refusing to decide these because you have no policies in place. And so it would not surprise me that when they respond to our summary judgment motion in Boston, which is due it'll be mid-June, that all of a sudden they've announced some policy to get rid of, to address that. And again, the personality of the administrator, who was a really nice guy, don't get me wrong, but he was not excited at the possibility of additional litigation. And we've seen reactive disclosures through the cases we've brought. And so all of a sudden we learned something brand new that's supposedly been in place for 2 years because it helps their litigation position.
Right.
And so that's my setting up for failure, predicting that in the next 60 days they will announce something and it may make its first appearance in court.
Well, and like Brad said, with this not being a big bureaucratic lift, I thought, I look at 9089s and I know how much work employers and attorneys put into making sure those are done properly. There's a lot of work that goes into a 9089. They take hours worth of work. And so I was expecting to hear, USCIS in their fee regulations always publishes the touch time, how long it takes them on average to do a certain type of form. they are, was it their deal with the labor union is that each takes about 11 to 13 minutes for an adjudicator. But the OFLC head was very excited that last quarter, 8 minutes was their average to do it per. And so 8 to 13 minutes to do these things, 13 hours. Dude, was just shocking to a lot of people, I think.
Yeah, then they should be getting through more.
So,
yeah.
Well, and then it makes you wonder, what depth of analysis are they doing if it takes 8 minutes?
Well,
right?
sure.
And what the administrator said was they look for completeness, internal consistency, and kind of very high level, does the beneficiary have a degree? Which is interesting to me because when you do a 9089, as you know, you cannot submit an incomplete application or one that has inconsistent data, right? So these analysts are just redoing the analysis that the robot did. And it's all based on attestations, right? And
Sure.
so if you're lying, you're dying. It just...
But they can't check for that. They can't check that you're lying. They don't know how to do that. They have no process in place. Not that I would advocate for that, because it'll bite you on the eye.
Right.
Yeah. I mean, the only way they're checking it is through an audit, right? And then you show the receipts of all the recruitment and things you're claiming were done. Interesting, man. I feel like you guys are sort of pulling back the curtain. This has been really enlightening. And Brad, we're going to be looking for the DOL announcement in June. So thanks for that. I know this is kind of a pie in the sky next question, and you all have been making these changes through litigation, like the concurrent adjudication for dependents and work authorization incident to status. But what would make your list for what you could see if USCIS or Department of Labor would make regulatory change, which again, we haven't seen. And, apart from complete immigration reform, which everybody wants, but knows that that's not coming, especially in an election year. What would be top of your list for a regulatory change?
Yeah, I think in terms of improving the things that are there. I mean, I know I would love to see more push for things to better the livelihoods for the backlog community, giving them more flexibility either through EADs and AP. But if we're going to talk about not creating new systems, I mean, automatic extensions of the advanced parole would be great. I'm tired, I hate talking to people when they are calling me that they are more concerned with the immigration impact of a funeral than, attending a funeral than worrying about their family. And it's not that I don't like talking to those people, but that's where we are in an immigration system.
Right.
And I think there's a lot that can be done through regulation to improve the lives of people that are going to be stuck waiting decades for green card or, green cards that are easy regulation changes, more automatic extensions. And then, Brad and I have talked about this. If they just look at what they said they were going to do and relook at their regulations and statutes, I mean, it took 20 years for L2 spouses to get work authorization incident to status, even though it's very clear that that's what Congress wanted. So
love it.
See what you have to say.
Yeah.
Yeah. At this point, I would just be happy with them engaging in rulemaking. I think the most extreme example of this is the EB-5 program, right? EB-5 was originally passed in 1990. Then the Regional Center program was passed in 1992. And then they engaged in rulemaking in 1994. And that is the set of regulations in place today, right? In 2013, after EB-5 started working, they didn't engage in rulemaking. Instead, they passed this 19-page memo, right? That did not go past litigation counsel at DOJ at the time, which was very frustrating. But they tried to do a rulemaking in 2019. It got set aside because of the structural problems at Homeland Security. And now under the new law, they're blatantly trying to regulate through website posts, right? Announcing new rules, and imagine trying to advise those clients, hey, go ahead and invest $800K or $1.4K or 1.4 million, right? And here's maybe the rules, right? And so if they would just engage in rulemaking, I have like 3 or 4 lawsuits right now in the EB5 space where we would just say, if they would just engage in rulemaking, we would be fine. And so just using it as a mechanism would be a huge step forward.
Yeah,
and
I think
in listening to stakeholders too, and not just the attorneys and interest groups, but if they listen to the people that are actually impacted by this a little bit, I think they could see that there are very low hanging fruit options that they can do to make people's lives better without making huge systemic changes that is going to get Stephen Miller's organization suing them.
And why do you think rulemaking is so difficult, like across the board? Like it seems like Brad's saying, like they just don't engage in it. Why do you think there's this reluctance?
It's not difficult, right? DHS has always, since its inception 21 years ago, been terrible at rulemaking. Other agencies, not so much. And again, I just go back to the more mature agencies. I mean, by mature, I mean, they've been challenged from the get-go on their policies. And so like the EPA, right? They engage in rulemaking all the time successfully. And so I think it's just from the get-go. The other part about this is, and we see this in litigation all the time, DHS wants every immigration benefit to have some element of discretion. Every single one. Right. Even ones that, again, we had an argument in our perm delay case in Texas where they said, well, perm is discretionary. What? And, when you engage in rulemaking, you do tie your hands a little bit. And they love the freedom, right? And again, immigration is a unique constitutional space where the executive pulls its power from the plenary power doctrine, which means it's not from a line in the Constitution, but it's from the powers that allow the executive to fend off, invading armies. And so this pool of power is so deep. And courts continue to cite to those cases from the late 1800s and the 1950s to support that. And you see that in, even the most recent Supreme Court cases on big issues. And so, unfortunately, they have the authority to use a lot of discretion. But again, discretion from the user side decreases predictability, decreases certainty. And so you have that inherent conflict. And I know that's a little bit pie in the sky, but I think that's the real issue. They don't want to tie their hands because they don't think they have to.
That makes total sense and is so frustrating. I'm mindful of the time, but where can listeners find and follow you both and get updates on what you both are doing within the litigation space and immigration? Where can we find your content?
Well, both of us are pretty active. I still call it Twitter. I just have a hard time calling it X.
Okay.
At Banis Law and at ATTY Stephen Brown. Try to keep as much updates as we can on there, because I think it's the easiest way to communicate.
And I host events as the president of the Bernie Wolfsdorf fan club. I'm the president.
He's the first attorney that filed this perm case in Boston as the one that was admitted there before Brad and I pro-hoc did.
That's right. Bernie is the lead attorney on our perm case in Massachusetts. We like to do podcasts on Twitter, and if you're the stuff that we do is so niche. If you start Googling for it, you'll find us. And then there's a handful of other folks that do it too. But it's such a pleasure getting to work with Wolfsdorf, with y'all's firm and Stephen's firm as a one-man shop. It's a really fun experience, and then getting to work with the regulated community and the individuals when we share their frustrations that this completely unreasonable and arbitrary thing puts their lives on hold and hurts them. It hurts their kids. And I don't understand how the administration and the bureaucrats don't see that, because they certainly have policies that completely dehumanize these folks. And fighting against that is something I always want to do.
That's amazing. Thanks for saying that. I can feel your passion Stephen, any final thoughts or words you want to share?
No, yeah, I mean, we just, I do hope that we're going to get something good here on the perm here soon, and it's does have real impact. So, a lot of our clients are all over the place. We have someone who was granted asylum who's now seeking a green card. We have, 6-year max out issues. We have people not from the backlog community that are waiting there. So we have people from the backlog community who finally were able to file a perm, but file a green card, but lost their job and have to go through the perm process again. This perm issue impacts a lot of different communities and a lot of different businesses. And I think it makes it very unique, that with the push, and we're hoping we're going to have a good change here soon.
Amazing. Well, we're big fans of you both, Brad and Stephen, and thanks for all the work that you're doing, and thanks for coming on the Business Immigration Benchmark today.
Thanks,
y'all.